It's just about 9:30 on this Wednesday morning, and as is our tradition, it's time to call our lawyer and friend, Bruce L. Scheiner of Bruce Scheiner and Associates, find out about our Ask the Lawyer segment of the week at Kicks Country 92.9. Would you please help me welcome Bruce Scheiner? Good morning, sir.
Hey, good morning, Todd. How you doing this morning?
Just doing fine, thank you. How about you?
I'm doing great, as well as we could expect under these conditions.
Yeah, and I wanted to ask you about that, your thoughts on that, because I know that you, like everybody else, you've had to make some adaptations in the way you conduct business and so forth. How are things going?
Well, we had two employees in our office test positive.
Oh, my.
But we're all social distancing. We only have a minimal staff in the office. Everybody's hooked up and working remotely, and we're conducting business as usual.
Right, because regardless of what's going on with the virus, people still need legal help, and that's what you're all about.
That's true, Todd.
Okay. Well, if it's okay with you, I'd like to jump right into today's Ask the Lawyer question, and then we can seek some feedback from you and see what direction perhaps this person could go.
I'm ready.
All right, here we go. This is what I was reading earlier this morning and sharing with the crew, and we were all kind of speculating on how this might play out. It says, my wife was in the garden section of a local hardware store when she tripped over a display in the walkway. It caused a rack of pest products to fall on her, and in the process, she fell and broke her hip. She was taken to the hospital by ambulance. She had to get a hip replacement, and the medical bills are over $50,000. The store owner claims he's not responsible because it was the manufacturer's representative who was setting up the display, not his employees. I tried to contact Baxter, but they're refusing to respond. Can a lawyer help me get someone to respond? It's so funny because in a case like this, they never want to respond, do they?
They sure don't. They want to hide in the corner and hope the injured party's going to go away.
Does that happen sometimes? Do people sometimes get so frustrated at the lack of response and so forth that they just kind of give up?
Well, in my experience, they don't give up. They call us and we help them.
Okay. All right. That's definitely the direction we want to point this particular email writer. But what are your thoughts on that exact situation?
Well, my thoughts are, we don't know exactly what happened, but if the manufacturer's representative caused a dangerous condition in the store, first of all, the manufacturer would be liable.
Okay.
But that doesn't take away the liability or responsibility of the store owner. The store is still responsible for what happens in the store, and they can't shirk their responsibility by trying to blame it on someone else.
I see. This has actually become a fairly common thing these days. I'm sure we've all seen in the stores where there is a jobber, so to speak, who is restocking bread or milk or whatever. And so a lot of times these people don't work for the stores, but if they're working on store property, there is some responsibility?
Yeah. The store, the business owes a responsibility to the customer to have a safe place to shop. You know, whether it's Publix or Walmart or Walgreens, you can expect to go in and enjoy a safe place to do business.
And this is what we were debating prior to calling you this morning. We were saying that perhaps what should have happened here is the store manager should have gone behind that manufacturer representative to double check the work and to make sure that they had left the product in a safe way.
Absolutely.
Okay. Well, that sounds promising anyway, especially with $50,000 in bills and hip replacement surgery and that kind of thing. That's very painful and very long and drawn out. So I would imagine there'd be some pain and suffering and that kind of thing here.
Oh, it's a very substantial case. But the bottom line, Todd, is when you get hurt severely like this,
Mm-hmm.
and you think it's because of someone else's responsibility, you should always call an experienced personal injury lawyer and review those facts, because there's usually a way to proceed.
And I know that, for example, you and your associates offer a free consultation. I'm going to give out the Port Charlotte office phone number here for exactly that reason. So there's absolutely no harm in bringing this to a legal professional and saying, what do you think?
There is no harm, and as you said, there's no charge unless we make a recovery for the client. So there's no reason not to call. Said conversely, there's every reason to call, because they could, help you make obtain reasonable restitution.
Right, and I think there's a good object lesson here, too. If you're going to try to pursue something like this on your own, you're more than likely going to hit the same brick wall of no return phone calls, no return emails, and nobody respond, or even worse, a response saying, we're not responsible.
That's true, Todd.
Okay.
Unfortunately, the industry has created a brick wall, and unless they have concern that you're going to pursue it, or there's a competent personal injury lawyer on the other side, they're going to normally stonewall you.
And ultimately, this is going to end up at somebody's insurance company, and insurance companies are specialists in sort of pushing this off and kicking the can down the road, so to speak.
Yeah, we find that very often.
Yeah. All right, Bruce. Well, this provides a little light at the end of the tunnel, and that's what we were hoping for. That's what we typically get from you. Thank you so much for weighing in this week.
Well, thank you, Todd. And it's, again, another very interesting fact pattern. I enjoy testing my law school memory.
Yes, indeed. And we're glad to put you to the test, and we look forward to talking to you next week.
I do too, Todd. Hope you stay safe and keep your wearing the mask and social distancing.
You got it, sir. And you too.